Hi everyone, in this video we will be talking about attorney fees and the different types that we have and helping you understand the different terminology so that you can make a better choice for you and your legal issue that you're dealing with. And these are going to be specific to California, so if you're watching from a different state, these do not apply to you. So in California, we have different fee structures, and depending on the fee structure, you have different legal obligations to the client as the attorney and the client to the attorney as well for financial obligations. So let's start with hourly fees. Hourly fees are basically an hourly rate that the law office will charge you for some work that they need to do for you. So if you ever call a law office and they tell you that they charge you hourly, that means that the attorney, the paralegal, the team, they actually have set hourly rates. What that means is, for example, if the hourly rate is $500 and they do a half hour of work, they will charge you $250 for that specific task or the work that they did that was legal. The paralegal will have a different hourly rate, their administrative team might have a different hourly rate. All of these hourly rates will be disclosed to you in an attorney-client retainer agreement, fee agreement. That fee agreement you will review, and in that fee agreement you will notice what the attorney rate is, what the paralegal rate is, if there's administrative costs or rates that you also need to be paying before you sign. So make sure that you're reading that thoroughly before you're agreeing to these rates, because the hourlies can actually rack up really quickly, and before you know it, you are billed thousands of dollars. So I'll give you an example of how our office does hourly rates with respect to trust administration. So when a person dies and they left behind a trust, we normally charge an hourly rate. For example, let's say $500 is my hourly rate in this hypothetical. What I will do is for every task that I do for that client, I will write it down and I will specify the amount of time it took me to do that task. And as attorneys, we divide the hour into increments of 6 minutes so that we can bill based on a decimal. 0.1 is 6 minutes, 0.2 is 12 minutes. So if a phone call takes me about 10 minutes, I bill the client the next highest billable decimal, which is a 0.2 for 12 minutes, even though I didn't talk to them for 12 minutes. It was only 10 minutes. My fee agreement says that I'm going to be billing for the next highest, and that is the norm in the industry. You don't go down, you go up as the attorney. So if I have a task where I am drafting something and it takes me 30 minutes, I will bill a 0.5 on my time. And at the end of the month, we will collect everybody's time from the office and we will send it to the client in an invoice that specifies what was done, how much time, and by who, and what their hourly rate is. And the client would have already agreed to all of this. They will review the bill. And what we do is we normally ask for an upfront larger amount from the client that we deposit into our client trust account, and we will take from that money the total amount that we've actually worked. It's kind of like a prepayment that goes into the client's trust account. And by trust, I don't mean estate planning trust. I mean a client bank account that is money that's specific to that client. And if at the end of the month I've billed $1,000 of work, I will see how much money that client has in that bank account of theirs, and I will ask for it to be transferred total of $1,000 because that's how much we've done, and so forth and so on for the proximate next month and the next month and the next month, until that client trust account, bank account is depleted and there's nothing, at which point we normally ask the client to send us. That's an hourly basis for doing legal work. Now, we talked about a client trust account, and I want to explain that a little bit more because I think this is where some confusion comes from clients. Whenever a client or an attorney is asking you for a retainer to deposit into a client trust account, what that means is that the attorney is taking that money from you. They're not putting it into their business account. They haven't earned that money. They're putting it aside in a special account known as a client trust account. In California, we call it an IOLTA account. We put it in that special client account, and we're not allowed to touch it until we earn that money. So when you send a client an invoice for $1,000, you say, here's how much I earned this month. I'm going to take it from your client trust account and put it into my bank account because I've earned it. And so for most cases or for most issues that you're dealing with an attorney that's demanding a client retainer amount up front, basically they just want to know that you're good for it and that you're actually going to pay your bills before they start doing all the work. So if it's a pretty large litigation matter, let's say you have an ongoing dispute, the attorney or the law firm could demand, let's say $25,000 or $30,000 up front to put in your client trust account to work towards. For example, for trust administration, we might ask you for a retainer of $5,000 to put into the client trust account to bill towards. So it just depends on the legal matter. Will determine what the actual client retainer amount is. And then you have full access to your client trust account. So at any time you can demand from your attorney to know how much is in there, what was spent from it, what was transferred or earned. The attorney should be giving you a monthly invoice with all of the details of what they're charging you. If they're not, if they can't give you an answer of exactly what the balance is on your client trust account, they're violating some California standards. So that's a client trust account and an hourly fee arrangement. Now let's fast forward to the second type of arrangement that we have here in California that needs to be in writing, and that is called a contingency fee basis. So a contingency is basically what it says. The case or the fee that the attorney earns is contingent on the result of the case. And you might know about this or have had some experience with it in personal injury matters, where the attorney will say, I will represent you in this car accident case, and I will not get paid until you are paid at the end. So when the attorney obtains a result for you, he will take a certain percentage of that result as his fee. These arrangements need to absolutely be in writing, signed by you as the client and the attorney, so be very careful. So if they're charging you 1/3 of the result, it needs to be in writing. Furthermore, if they're charging you a different rate before filing a lawsuit or after a lawsuit, it also needs to be in writing. So that's the most common type of fee arrangement, anytime that you are the victim or something happened to you and the attorney is representing you to recoup fees that are owed to you or that you've been harmed in the amount of. Now, there's one other fee arrangement, and that is a flat fee arrangement where the attorney will say, you know what, I'm not going to charge you hourly, I'm not going to charge you contingency, I'm going to let you know what the total cost of all this legal work is going to be upfront, and if you agree with it, we could work together. So for our office, we do our estate planning work on a flat fee basis for most clients. So if you call in to ever get a consultation, you would have been given a flat fee amount or an estimate of what your legal fees will be. For example, we might say, okay, that estate plan will cost $3,000. Flat fee, we're not going to charge you additional, we're not going to charge you hourly for the work. We're going to charge you exactly what we've said we're going to charge you and no additional monies. So that is a flat fee basis, and there are some practice areas of the law where we are able to do a flat fee because we anticipate and know the type of work that it's going to take for your situation. So those are the three most common fee structuring systems that we have in California. Feel free to leave a comment down below if you have questions about these topics. And if you have suggestions for other topics you'd like to hear from us on, feel free to leave it down below in the comments and we'd be happy to film a video on it.